Imagine it's your first week at a new job. You're excited. The salary is good, the team seems cool, and HR sits you down with a big stack of papers and says, just standard onboarding stuff, go ahead and sign wherever there's a tab. You don't want to seem difficult. You don't want to start off on the wrong foot. So you flip through the pages, sign where they tell you, and hand it back with a smile. Fast forward 2 years, you get called into a meeting. They let you go. You think, okay, this doesn't feel right. I'm going to talk to a lawyer. And the lawyer looks at everything and says, I'm sorry, you signed an arbitration agreement on day 1. You gave up your right to sue them before you even started. That one signature, that one moment where you just went along with it, just cost you everything. And here's the worst part. This happens every single day. Smart, hardworking people handing over their rights with a pen because nobody ever told them what they were actually signing. Until now. What's up, everyone? It's Saluna. Welcome back to Saluna versus the System, the channel where we break down the stuff the system hopes you never figure out, your rights, your money, and how to stop getting taken advantage of. Today, we're covering 7 work documents you should never sign on the spot, what each one actually means, why each one puts you at risk, and the exact words you can use to buy yourself time and protect your future. Let's get into it. 1. The arbitration agreement. You might see this during onboarding or when HR sends around a policy update. They'll call it standard paperwork, but here's what it actually does. The moment you sign an arbitration agreement, you give up your right to take your employer to court. Any future dispute, wrongful termination, discrimination, unpaid wages, gets handled by a private arbitrator instead of a real judge and jury. Think of it like this. Instead of going to court where the process is public and the rules protect you, you're now in a private room with a decision maker who the company has far more experience dealing with than you do. The proceedings are confidential, your right to appeal is almost non-existent, and bad company behavior never sees the light of day. What to say instead? I'll review this and get back to you by date. Ask if there's an opt-out window. Many agreements have one. If they pressure you into signing on the spot, sign it, but right next to your signature, received under review. I do not agree to arbitration. That creates a record that you did not consent, and that record matters. 2. Non-compete and non-solicitation agreements. A non-compete says you can't work for a competitor for a certain period of time after you leave. A non-solicit says you can't reach out to former clients or coworkers to bring them to your new company. Sounds reasonable on the surface. Here's where it gets dangerous. Vague language. Phrases like any business similar to ours or any client the company has ever had can turn a narrow restriction into a career-ending trap. You could accidentally be signing away your ability to work in your own industry. What to say instead? I need time to review the scope, geography, and duration of these restrictions. Then negotiate. Ask them to narrow the territory, shorten the timeline, and get specific about which clients are actually off-limits. And if they want to restrict your future income, ask them to pay for it through severance or what's called garden leave, where they pay your salary during the non-compete period. 3. Severance agreements. When a company lays you off or lets you go, they might hand you a severance agreement, a check in exchange for your signature. Sounds like a win. Here's where the trap is. That signature means you're releasing all legal claims against them. Wrongful termination, discrimination, unpaid wages. You're giving all of that up, often for far less than you'd actually be entitled to if you pursued it. And buried inside these agreements, confidentiality clauses that prevent you from talking about what happened, non-disparagement clauses that stop you from saying anything negative about the company, even if it's completely true. What to say instead? I appreciate the offer. I'll review this and respond by date. Here's the power move. If you're over 40, the law requires your employer to give you at least 21 days to consider the agreement and 7 days to revoke your signature after signing. Use every single one of those days. Negotiate for more money. Ask for a neutral reference. Push back on the restrictive language. You have more leverage than they want you to think. 4. Resignation in lieu of termination. This one's one of the sneakiest ones. A manager pulls you into a room and says, "Look, I'm trying to help you here. If you resign, it'll look better on your record. Let's part ways on good terms." Don't do it. The moment you sign a resignation document, you almost certainly lose your eligibility for unemployment benefits, and you hand the company a clean, simple defense against any wrongful termination claim, because you quit. They're asking you to do their dirty work for them. They want the outcome of a firing without any legal exposure. What to say instead? If the company is ending my employment, I need that in writing. I will not be resigning today. Then stop talking. Don't argue, don't get emotional, and immediately after that conversation, send an email to HR that says, "To confirm, manager name asked me to resign today and I declined. If my employment is being terminated, please provide that in writing." Now you have a time-stamped record of exactly what happened. 5. The PIP acknowledgement. We talked about PIPs, performance improvement plans, in a previous video, but here's the piece most people miss. When they hand you a PIP to sign, they make it look like you're just acknowledging you received it, but read the fine print. Often, that signature line means you're agreeing with the facts stated inside. You're essentially signing a confession, admitting to poor performance, admitting to policy violations that will be used against you to deny unemployment benefits or defeat a future lawsuit. What to write instead? Next to your signature, write, "Acknowledging receipt only. I disagree with the statements and conclusions herein and will provide a formal rebuttal." Then submit a short, factual rebuttal. Stick to dates, metrics, and evidence. Point out where you lacked training, tools, or support that was promised. Keep it professional, keep it factual. 6. Disciplinary write-ups. Same trap, different document. You're in an uncomfortable meeting. Everyone wants it to be over, and the write-up form is sitting right there with a signature line. Maybe it even has pre-written language like, "I accept responsibility," or "I admit I violated company policy." If you sign that as is, you've handed them a legally binding admission on a silver platter. What to do instead? Write, "Receipt only. I disagree with this write-up and will be providing a rebuttal." Keep your rebuttal to one page. Use timestamps, reference emails, name witnesses if you have them. No emotion, just facts. If they refuse to let you add notes, say, "Then I will email my rebuttal for my personnel file." Send it immediately to HR and your manager with the subject line, "Rebuttal to disciplinary action, -date." Your side of the story is now on record. 7. Broad medical release or investigation authorization. This one flies under the radar because it sounds routine. You request medical accommodation or you're involved in a workplace investigation and HR hands you a form to sign. Here's the trap. These forms are often intentionally written to be as broad as possible. A medical release might give the company access to your entire medical history from every doctor you've ever seen. For an accommodation, they only need to know your work-related limitations. That's it. An investigation authorization might give them permission to search your personal devices or social media. What to say instead? I can provide a more targeted authorization. For medical issues, ask your doctor to write a specific letter describing only your functional limitations, what you can and cannot do at work. For an investigation, offer to provide specific relevant documents yourself. You control the scope. Don't sign a blank check. So let's recap the 7 documents you should never sign on the spot. 1. Arbitration agreements. 2. Non-compete and non-solicitation agreements. 3. Severance agreements. 4. Resignation in lieu of termination. 5. PIP acknowledgments. 6. Disciplinary write-ups. 7. Broad medical releases or investigation authorizations. And here's the rule that ties all of this together. Slow down and control the record. Never sign anything on the spot. Always say, "I'll review this and get back to you."
Add receipt only when a signature is forced, submit factual rebuttals in writing, and never sign away your legal rights under pressure. This isn't about being difficult, it's about being strategic, because here's the reality. The company has HR, they have lawyers, they have processes built specifically to protect themselves. The least you can do is protect yourself, too. Your signature is powerful. Treat it that way. If this video helped you, hit that like button and subscribe. We drop new content every week on exactly this stuff. And drop a comment below. Has anyone ever handed you a document and pressured you to sign it on the spot? Let me know what happened. See you in the next one.
Imagine two people join the same company the same month. Same title, same salary, same starting point. The first one, let's call her Maya, does everything right. She works late, she fixes broken systems, she never misses a deadline. She covers for teammates who quit and never get replaced. 3 years in, she's exhausted, underpaid, and somehow still waiting for the promotion that keeps getting pushed to next quarter. The second one, let's call him Tyler, works smart, not hard. He's in the right meetings, he says the right things to the right people. He takes credit for collaborative work without apology. He makes his manager look good in front of directors. 18 months in, Tyler is a team lead. Maya is still being told to be patient. Here's what Maya never understood. She was playing by the first rulebook, the one they hand you during onboarding, the one with the company values and the performance review criteria, and the promotion process that's supposed to be based on merit. Tyler was playing by the second rulebook, the one nobody hands you, the one that actually determines who moves up, who gets protected, who gets overloaded until they quit, and who walks through the whole system completely untouched. The gap between those two rulebooks, that's where careers go to die. Today, we're handing you the second one. What's up, everyone? It's Saluna. Welcome back to Saluna versus the System, the channel where we pull back the curtain on the games being played at work, with your money and with your career, so you can stop losing without knowing why. Today, we're going through 15 rules from the employee handbook they never gave you, the unwritten rules that actually govern who gets promoted, who gets used up, and who finally figures out the game before it's too late. Let's get into every single one. Rule 1. Your boss doesn't reward effort, they reward usefulness to their goals. You stay late rebuilding a system that saves the team 10 hours every week. Nobody mentions it. Meanwhile, someone else puts together a slide deck that makes your manager look sharp in front of a director. That person gets named at the all-hands meeting. You get assigned more work. The difference wasn't quality. The difference was who benefited. Labor that makes power look good gets recognized. Labor that disappears into the infrastructure gets consumed. If nobody with authority can see what you did and connect it to something they care about, you didn't do valuable work. You did invisible work. And invisible work builds invisible careers. Rule 2. Reliability is rewarded until it becomes exploitable. In the beginning, being dependable gets you praised. Then the assignments shift. You get the understaffed project, the impossible deadline, the coverage for the person who quit 3 months ago and was never replaced. And every time it arrives with the same line, "We're giving this to you because you're the only one we trust." That's not recognition. That's your willingness being used as a staffing plan. Once the organization maps you as someone who absorbs dysfunction, it will keep feeding you chaos until you break or leave. Nobody will check on you before either happens. They'll check on the project. Rule 3. Visibility beats quiet excellence. Every time. You built the project. Someone else walks into the meeting and summarizes it. Everyone nods. Your name is never said. 3 weeks later, that person is described as the one who led the initiative. The work does not speak for itself. It never has. If it cannot be seen, it does not count. And if someone else is seen standing next to it first, it becomes theirs. Rule 4. Promotions don't go to the best performer. They go to the safest political choice. A director has 2 candidates. One is sharp,
independent, delivers results, but asks hard questions and doesn't fold easily. The other is less impressive, but agreeable, predictable, and easy to manage. The second one gets promoted, not sometimes, routinely. Leadership promotes the person who threatens least, and the one who got passed over gets told to keep delivering, as if performance was the part that failed. Rule 5. The person who controls the narrative controls the outcome. Your performance is not defined by what you've done. It's defined by what gets said about you in rooms you're never invited into. One sentence from a senior leader can reshape your entire trajectory. She's great technically, but not strategic. That label doesn't need evidence. It just needs repetition. Once it sticks, every single thing you do gets filtered through it. You're not told it's happening. You just feel the temperature drop. Doors that used to open start staying closed. And you keep working harder thinking effort is the issue. Effort was never the issue. Rule 6. HR exists to protect the company, not you. When you file a complaint, what activates is a containment process. The question being asked behind closed doors is not, was this person wronged? It is the organization exposed? The employee who walks in expecting advocacy and receives procedure instead is not experiencing a broken system. They are meeting the system for the first time. Rule 7. Being liked matters. Being easy to manage matters more. A competent employee who pushes back, escalates problems, and requires honest engagement on every decision is exhausting to manage. A less competent employee who agrees, absorbs direction, and never makes the morning harder is a relief. Managers under pressure will choose relief over time. The people who made things smooth get promoted. The people who made things right get managed out, not for being wrong, but for being work. Rule 8. Boundaries are only respected after someone costs something. You can say no. You can explain your limits. You can be clear about your bandwidth. None of it matters if your behavior keeps saying yes. A boundary that bends every time it's tested is not a boundary. It's a suggestion, and suggestions get ignored.
Rule 9. You're being evaluated on how controllable you are, not just how good you are. You're performing well. You start asking for things that match. Credit, equity, input on direction. And then something shifts. It's not sudden, it's tonal. Your manager's replies get shorter. Meetings you used to be pulled into stop appearing on your calendar. You're not doing anything wrong. You're doing something uncomfortable. You're becoming harder to steer. The system doesn't punish that directly, it reclassifies you. You move from high potential to needs alignment. Nobody tells you, you just stop getting chosen for things you used to get chosen for. Rule 10. The reward for fixing chaos is becoming the permanent chaos absorber. You stabilized a failing project. You covered for 2 missing roles. You held a team together through a quarter that should have collapsed. And what did the organization learn? Not that you deserved more, that you could absorb dysfunction without escalating it. So instead of fixing the root cause, they kept handing you the wreckage. Your competence became the replacement for infrastructure the company refused to build. You were the fix. That was the problem. Rule 11. Loyalty is demanded downward and discarded upward. You were told to stay through the hard times, commit, show you're a team player. Then the budget shifts. Leadership changes direction. Your position becomes inconvenient, and that loyalty you demonstrated evaporates in a single meeting you were not invited to. You are expected to sacrifice. They reserve the right to be strategic. Both sides use the same word for it. Rule 12. Meetings are not for information. They're for power. Who gets asked for input? Who gets interrupted? Whose eye contact does the decision maker make? Whose idea gets repeated 10 minutes later by someone more senior and suddenly treated as original? You have sat in that meeting. You have watched your own words come back to you in someone else's mouth, while everyone nodded like it was the first time they heard it. Rule 13. Feedback is not always developmental. Sometimes it's compression. You were told to be less direct, less visible, less vocal. The language sounds developmental, more polished, better at reading the room. but the effect is reduction. You become smaller, softer, easier to handle, and you comply because you believe you're growing. If every piece of feedback you receive makes you quieter, it's worth asking who it's making you quieter for. Rule 14. Job security doesn't come from being essential. It comes from being essential in a way someone can explain in one sentence. You might be the most critical person on your team, but if the person making budget decisions cannot describe what you do, you are already gone. You just haven't been told yet. Value that cannot be narrated cannot be defended. When cuts come, the names that survive are not the most important. They are the most explainable. Rule 15. The biggest advantage you'll ever have at work is seeing the system clearly before it needs you to stay confused. Every rule in this list runs whether you see it or not. Praise is still functioning as extraction. Visibility is still outranking effort. Labels are still being written in rooms you'll never enter. Loyalty is still flowing in one direction. None of this stops because you're talented. But something does shift once you see it. You stop mistaking praise for protection. You stop treating access as loyalty. You stop performing harder when the problem was never performance. And you start reading the room you're actually standing in, not the one they described during orientation, the real one, the one that was always running underneath. Here's the truth I want you to carry out of this video. You were never failing. You were playing by the wrong rulebook, the one designed to keep you productive, compliant, and just hopeful enough to stay. The second rulebook, the real one, rewards visibility over effort, narrative over performance, and political safety over actual competence. Once you see that, you cannot unsee it, and you stop being the person they could never explain, because you finally understand exactly what game is being played. Know the rules, play smarter, protect yourself. If this video opened your eyes, smash that like button and subscribe. We drop content like this every single week. Drop a comment below. Which of the 15 rules hit closest to home for you? I read every single one. See you in the next one.
Imagine you've been at your company for 3 years. Good performance reviews, solid relationships, no real issues. But lately, something has shifted. Your manager has been piling on extra work, passing you over for opportunities, and treating you noticeably differently than everyone else on the team. So you do what any reasonable person would do. You go to HR. You sit down across from the HR rep. Friendly face, warm office, box of tissues on the desk, and you start talking. You tell her you've been stressed. You tell her the situation feels unfair. And at the end of the conversation, frustrated and emotional, you say the words that felt so powerful in the moment. If this doesn't change, I'm going to sue. You walk out feeling like you finally stood up for yourself, like you drew a line, like they know you're serious now. Here's what actually happened in that room the moment you left. The HR rep opened her laptop and started documenting. She noted that you reported difficulty managing your workload. She flagged that your complaint was about fairness, not discrimination, not anything legally protected. And she forwarded a message to the legal department letting them know you had threatened litigation. Within 48 hours, your personnel file is being reviewed, your emails are being pulled, your coworkers are being quietly interviewed, and every minor mistake you make going forward is being logged. You didn't just fail to get help, you handed them everything they need to build a case against you. And the worst part? You had no idea. What's up, everyone? It's Saluna. Welcome back to Saluna versus the System, the channel where we break down the things the system hopes you never figure out, your rights, your money, and the traps that cost workers thousands of dollars every single year. Today, we are talking about HR. Specifically, 3 things you should never say to HR if you want to protect your job and preserve your legal rights. And stick around for the third one because it is the most counterintuitive. It feels like power. It is actually the single biggest gift you can hand your employer. And quick disclaimer, Nothing in this video is legal advice. This is education only. Your situation is unique, and if you're dealing with something serious at work, please talk to an employment lawyer in your state. Now, let's get into it.
Number 1, never say, I'm stressed, I'm anxious, or I'm burnt out. You are overwhelmed. Your workload is impossible. You are running on empty and you genuinely need help. So you go to HR thinking they will redistribute your tasks, talk to your manager, or at least acknowledge that something needs to change. Here is what HR actually hears when you use those words. This person can't handle their job. And here is what they actually do. They document it. They write in your file that you reported difficulty managing your workload. They note that you are struggling with performance. And 3 months later, when they fire you, they have the perfect paper trail ready to go. They will say, we didn't fire this person for any illegal reason. They told us themselves they couldn't handle the workload. We had documented performance concerns. Here is the deeper legal trap inside this. The words stressed, anxious, and burnt out carry zero legal protection under U.S. employment law. Burnout is not a medical diagnosis. Stress is not a disability. Feeling anxious is not the same thing as a diagnosed anxiety disorder. There are federal laws, specifically the Americans with Disabilities Act, that protect employees with documented medical conditions. Generalized anxiety disorder, major depression, PTSD, those are protected, but everyday stress and burnout are not. So when you use those words, you give the company documentation without giving yourself any legal protection whatsoever. You get the worst of both worlds. Here is what to say instead. If you have an actual diagnosed medical condition, anxiety disorder, depression, anything documented by a healthcare provider, do not walk into HR and say, I'm stressed. Say this exact phrase, I have a medical condition and I need to discuss accommodations. Those are the words that trigger federal disability protections. Once you say them, the company has a legal obligation to engage in what's called the interactive process, a required back and forth to find reasonable accommodations. They cannot simply document you as a poor performer and push you out the door. They have to work with you first. But if you don't have a diagnosis, if you're just in a bad job with a bad manager, saying, I'm stressed to HR will only hurt you. It gives them a weapon. It gives you nothing. Number 2, never say, this isn't fair. You got passed over for a promotion, your manager is clearly targeting you, your coworker does half the work you do and never gets criticized, you are angry, rightfully so, and you walk into HR ready to say exactly how you feel. This isn't fair. You're treating me unfairly. Here's the problem with that. Unfair is not illegal. In America, employers are legally allowed to be unfair. They can play favorites, they can be inconsistent, they can make bad decisions and treat you worse than your coworkers for almost any reason or no reason at all. That is what at-will employment means. The law does not require employers to be fair. It only requires them not to discriminate based on protected characteristics. Protected characteristics include your race, gender, age, religion, national origin, disability status, pregnancy status, and others depending on your state. Protected activities include things like reporting discrimination, filing a workers' comp claim, or taking protected leave. So when you walk into HR and say, this isn't fair, you know what gets written down? Employee complained about fairness, not a legal issue. No action required. You have just told them you don't know your rights, and you have given them documentation that your complaint has no legal teeth. Here is what to say instead. If you genuinely believe you are being treated differently because of a protected characteristic or because of protected activity, name it specifically. Say, I believe I was passed over for this promotion because of my age, or I believe I am being treated differently because I previously reported discrimination. Do not say this if it isn't true. But if it is true, if you genuinely believe a protected characteristic is behind the treatment, those words transform your complaint into a legally protected one. Now, if they retaliate against you for making that complaint, you have a retaliation claim. That is a completely different legal situation than "it's not fair." Fair is a feeling. It has nothing to do with what the law protects. Thing number 3. Never say, "I'm going to sue you." This is the one that surprises people most because it feels powerful. You are furious. You want them to know you mean business. You want them to scare them into doing the right thing. But the moment those words leave your mouth, you are handing your employer the biggest gift they could possibly receive: time. Here is exactly what happens the second you threaten a lawsuit. HR ends the meeting. They contact the legal department to alert the company that litigation is coming. They pull your entire personnel file. They start documenting every mistake, every tardiness, every complaint anyone has ever made about you. They review your emails, your badge-in records, your internet history. They interview your coworkers looking for anyone who has had a negative interaction with you. They are not doing this to reflect on what they did wrong. They are doing this to build a defense against you. And if you are still employed, you just painted the largest possible target on your back. Here's the worst part. If the company has been doing something genuinely illegal, if there's real evidence of discrimination, retaliation, wage theft, you just warned them. You gave them time to organize their story, coordinate their witnesses, and in some cases, destroy evidence before you ever file anything. Destroying evidence is illegal. It's called spoliation, but proving it is incredibly difficult. And even when you can prove it, the evidence is already gone. Here is what to do instead. Say nothing. If you believe you have a legal claim, quietly gather your own evidence. Save emails to a personal account. Write down dates, times, and exact words used. Get copies of any relevant company policies. Then call an employment lawyer and let them evaluate your situation. If you have a case, your lawyer will take action strategically, often before the company even knows what's coming. The element of surprise is one of your most valuable assets in employment litigation. Do not give it away in an HR meeting because you wanted to feel powerful for 5 minutes. If you are going to sue, just sue. Do not announce it first.
Here is the rule that ties all 3 of these together. Treat every single HR conversation like it is being recorded and will be played back in a courtroom, because in a very real sense, it is. Everything you say gets documented, and that documentation can and will be used against you if things go sideways. HR is not your enemy, but HR is not your friend either. Their job is to protect the company from legal liability. When your interests and the company's interests align, they will help you. The moment they conflict, the company wins. Every time. So you protect yourself. You use precise language. You understand what words carry legal weight and which ones just hand the company ammunition. And when you think you have a real claim, you get a lawyer involved before you say another word to HR. Because in the workplace, what you don't say protects you just as much as what you do. If this video opened your eyes, smash that like button and subscribe. We drop content like this every single week. And drop a comment below. Has HR ever used something you said against you? Tell me what happened. I read every single one. See you in the next one.
Imagine you've been at your company for 4 years. Solid track record, good reviews, no real issues. But lately, your workload has been piling up and your manager keeps adding tasks that have nothing to do with your actual role. So one afternoon, completely frustrated, you say the words that feel totally reasonable in the moment. Look, that's really not part of my job. You weren't being difficult, you weren't being lazy, you were setting a boundary. You were being honest about your responsibilities. And in your mind, that was the mature, professional thing to do. But here's what your manager heard: insubordination. And here's what happened next. Over the following 3 weeks, your manager started documenting everything. Small mistakes that would have been ignored before suddenly appeared in emails. Your performance review came early and included feedback you had never heard once in 4 years. And 6 weeks after that one sentence, you were called into a meeting and let go. The reason on paper? Attitude and failure to meet job expectations. But the real reason? One phrase, said once in a moment of completely understandable frustration. This happens every single day. And today, we're going through the 4 phrases that employment lawyers see destroy careers, what makes each one legally dangerous, and exactly what to say instead. What's up, everyone? It's Saluna. Welcome back to Saluna versus the System, the channel where we break down the workplace traps nobody warns you about, so you can stop losing your job, your leverage, and your legal rights without even knowing why. Today, we're covering 4 phrases that are absolute career killers, the ones that sound perfectly reasonable, but hand your employer exactly what they need to build a case against you. Quick disclaimer, nothing in this video is legal advice. This is education only. If you're dealing with a specific situation at work, please talk to an employment attorney in your state. Let's get into every single one. Phrase number 1, that's not part of my job. This is the phrase that feels the most justified. You were hired for a specific role, you have a job description, and your manager is asking you to do something that has nothing to do with that description. So you say, that's not really part of my job. Here's the trap. Your job description is not a legal contract. It does not protect you the way you think it does. Because of at-will employment, which applies in most U.S. states, your employer can change your job duties at any time for almost any reason, as long as that reason isn't illegal. There is no law that says your responsibilities have to match what was written in the original posting. Your manager can expand your role, shift your assignments, and add new tasks whenever they choose. So when you refuse a task by saying it's not your job, even if you're technically correct, employers almost universally interpret that as insubordination. That's the specific word they use. And insubordination is one of the easiest paper trails to build when a company wants to justify a termination. You handed them the first brick. Now, there is one important exception. If what your employer is asking you to do is actually illegal, working off the clock, committing fraud, ignoring documented safety hazards, you should absolutely refuse. And you should put that refusal in writing so there's a record. That protects you legally. But for everything else, be strategic. What to say instead? I can take that on. What should I move down my priority list to make room for it? That one sentence does 3 things simultaneously. It shows you're a team player, it makes your manager acknowledge your existing workload, and it puts the decision about priorities back on them where it belongs. You've gone from a target to a collaborator in one sentence.
Can we talk off the record? This one feels like a smart move. You want to raise a concern, you want some privacy, so you pull someone from HR aside and ask if you can speak confidentially. Here is the hard truth. There is no such thing as off the record when you're talking to HR or management. This is one of the most common and most expensive mistakes workers make. An employee has a private conversation with HR. By the next morning, the person they complained about knows every single detail of what was said, and the worker is blindsided because they were promised confidentiality. Why does this happen? Because HR works for the company. Their paycheck comes from the business. Their loyalty goes to protecting the organization from legal liability. The moment you raise a concern, you have put the company on legal notice. And once they're on notice, they may have an obligation to investigate. And investigations are never private. That promise of confidentiality has 0 legal force behind it. So here is the rule. Before you say anything to HR or management, assume it will be shared word for word with the exact person you're talking about. If you wouldn't be comfortable with that person hearing it directly,
do not say it. What to do instead? If you have a legitimate complaint about illegal conduct, discrimination, wage theft, harassment, retaliation, make it in writing. A formal, documented complaint about illegal behavior triggers specific legal protections. A casual, off-the-record conversation triggers nothing except gossip. Put it in writing, name the specific illegal conduct, and keep a copy for yourself. Phrase 3. I'm interviewing with another company. You're frustrated. You want leverage. Maybe you think telling your boss you're looking elsewhere will shock them into giving you the raise or the recognition you deserve. The second those words leave your mouth, you are no longer seen as part of the team. You are now a flight risk and potentially a security concern. From that moment forward, your manager's priority is not keeping you, it's replacing you. They will start quietly shifting your most important work to other team members. They will begin documenting your performance in ways they never did before. They will start the process of finding your replacement while you are still sitting at your desk. And because of at-will employment, they can let you go the moment it becomes convenient, which is often the moment your replacement is ready. Here's what makes this even more dangerous. More often than not, the moment you formally tell your current employer you've accepted another job, they terminate you on the spot to protect company data and client relationships. You planned to work out your last 2 weeks. Instead, you're escorted to the door the same afternoon. The rule? Keep your job search completely private. Keep your job change completely private. Only share that you've accepted another offer after you have a signed offer letter and are close to your start date. And understand, you are not legally required to give 2 weeks' notice. Sometimes it's strategic, sometimes it's not. But that decision should always be yours to make on your own terms. Your career moves are your business, nobody else's.
This one surprises people the most because it sounds so harmless. You're running late, you seem distracted, you need a day off, and you say, "I'm sorry, there's just a lot going on personally right now." You're trying to be honest. You're trying to build understanding. You're being human. Here's the problem. Vague personal disclosures give your employer ammunition to label you as unreliable or not fully committed to the job. Employers hear there's a lot going on in my personal life, and they start connecting dots you never intended. If your performance dips even slightly over the next few weeks, they have a ready-made explanation: the personal distractions. If layoffs come and someone has to make a list, your name is now associated with instability and divided attention. And in an at-will employment state, which is most of the US, they don't need to prove you were actually distracted. They just need a plausible-sounding reason on paper. You just handed them one. I've seen this happen over and over. Someone says it to build empathy, and what they trigger instead is a quiet shift in how their manager perceives them, from valued team member to risk we need to manage. What to do instead? If you need time off or accommodations because of a serious medical condition or a qualifying family situation, there are laws that protect you, the Family and Medical Leave Act, and various state equivalents. Use them. Make a formal, specific request under those protections. That keeps the conversation focused on your legal rights, rather than giving your employer a vague narrative they can use against you. Keep the personal details personal. The workplace is a business relationship. Treat it like one. Let's bring it all together. The 4 phrases that can end your career. 1. That's not part of my job. Manage priorities instead of refusing tasks. 2. Can we talk off the record? There is no off the record. Put legitimate complaints in writing. 3. I'm interviewing with another company. Keep every career move completely private until you're ready to walk out. 4. There's a lot going on in my personal life. Use formal legal protections instead of vague personal disclosures. Here's the principle behind all 4 of these phrases. You are in a business relationship at work, not a friendship, not a family. A business relationship where you are your own best and only advocate. The company has HR, legal teams, and documented processes all designed to protect itself. The least you can do is protect yourself too. Be strategic.
Be deliberate and never give anyone a reason on a silver platter. If this video helped you, smash that like button and subscribe. We drop new content every single week on exactly this, and drop a comment below. Have you ever said one of these phrases at work and felt the consequences? Tell me what happened. See you in the next one.
Imagine you've been dealing with a hostile work environment for months. Your manager has been making inappropriate comments, you've been passed over for promotions you clearly deserved, and one day they finally push you too far and you decide to take legal action. You hire a lawyer. The case looks strong. You have witnesses, you have dates, you have a clear pattern of behavior. Your attorney tells you this is a solid case. Then discovery starts. That's the phase of a lawsuit where both sides have to hand over evidence, and the company's lawyers send over a request for all text messages related to your employment. Your coworker, your friend, the person you vented to every single day has to comply. The court orders it. And suddenly, on a screen in a conference room, a lawyer is reading a text you sent 8 months ago. LOL, that's so wrong. Sent right after your manager made the inappropriate comment you're now suing over. Honestly, I've been job hunting for a while. I'm so over this place. Sent 3 months before you were forced to resign. Hey, can you just clock me in? I'm running 10 minutes late. Sent on a random Tuesday that had nothing to do with anything. Your strong case just fell apart, not because you were lying, not because the discrimination didn't happen, but because of text messages you forgot you sent to someone you trusted completely. What's up, everyone? It's Saluna. Welcome back to Saluna versus the System, the channel where we expose the traps that cost workers their jobs, their money, and their legal rights, so you can stop losing before you even know the game has started. Today, we are talking about 4 text messages you should never send to a coworker, what each one does legally, why even your closest work friend can't protect you once a lawsuit begins, and the one rule that will keep you protected no matter what. Quick disclaimer, nothing in this video is legal advice. This is education only. If you're dealing with a specific situation, please talk to an employment attorney in your state. Let's get into it. Text number 4, the awkward acknowledgement text. Here's the scenario. A coworker or supervisor texts you something completely inappropriate. Maybe it's a dirty joke. Maybe it's a comment about your personal life or your medical condition. It makes you deeply uncomfortable, but you have to see this person at the office tomorrow and you don't want to make things weird. So you send back a laughing emoji or a thumbs up or just LOL. That text just walked you straight into a legal trap called the unwelcome standard. Here's how it works. If this person continues harassing you or creates a hostile work environment and you eventually file a lawsuit, one of the things you have to prove is that their conduct was unwelcome. That's a legal requirement, and the company's lawyers are going to pull those text messages and say, look, they laughed, they sent emojis, they didn't ask them to stop, they welcomed the behavior. And here's the brutal truth. That defense can work. Courts have ruled in favor of employers based on exactly this kind of evidence. Your laugh emoji just became the thing that killed your harassment case. What to do instead? If you get an inappropriate text, the safest response is to say directly, I don't appreciate that. Short, clear, on the record. If you want to avoid confrontation entirely, don't respond at all. Silence is legally neutral. A laughing emoji is not. Text number 3, the I'm looking for another job text. You're frustrated, you're underpaid, you're being treated badly, so you text your work friend, honestly, I've been applying to other places, I need to get out of here. Seems harmless. Here's the legal problem. That text can destroy a specific legal claim called constructive discharge. This is the claim you make when you weren't technically fired, but the working conditions were so intolerable, so hostile, so unbearable that you were essentially forced to resign. Constructive discharge allows you to sue for wrongful termination, even though you were the one who walked out.
But to win that claim, you have to prove your resignation was a desperate response to the abuse, not a calculated career move. If the employer finds a text from 3 months earlier where you said you were already job hunting for a better salary, your constructive discharge claim is gone.
They'll argue you were planning to leave anyway, that your resignation was voluntary, that they didn't force you out. You were already on your way out the door. There's also a secondary trap here around mitigation of damages. If you texted a coworker that you turned down a job offer or that you were taking a break from your job search, the employer can use that to argue you didn't make enough effort to find new work. That directly reduces the amount of lost wages you can recover, even if you win your case. The rule: your job search is your business. Keep it completely private until you have a signed offer letter and you're ready to give notice. Text number 2, the trash talk text. Bad day. Your manager micromanaged every move you made. They made a decision that made absolutely no sense. You're furious. So you text your coworker, "I hate him. He's such an idiot. I genuinely cannot stand this man." We all need to vent. The problem is doing it in writing. Here's the legal mechanic behind this one. It's called burden shifting. If you sue your employer for discrimination or wrongful termination, the burden shifts to the employer to provide a legitimate, non-discriminatory reason for firing you. Often, they just make one up. They lie. They'll claim you had a terrible attitude, that you were disrespectful, that you were toxic to the team. Your lawyer's job is to prove that reason is a lie. In employment law, that lie is called pretext, a fake justification designed to cover the real illegal reason. But if the employer finds screenshots of you calling your manager names, you just made their lie look completely believable. They'll put that text on the screen and say, "We didn't fire this person for an illegal reason. We fired them because they were toxic and disrespectful. Here is the proof, right here in writing." You handed them the cover story. You made pretext look like truth. The rule: if you need to trash talk your boss, do it out loud, in person, with someone you trust. Never put it in writing, ever. Text number 1, the bend the rules text. This is the most dangerous one on the list, and it's the one that feels the most innocent. "Hey, I'm running 10 minutes late, can you just clock me in? I'm almost there. I forgot to sign the safety log, can you just initial it for me real quick?" Small favors between friends. Happens all the time. Nobody thinks twice about it. But legally, you just documented a valid reason for your termination, and it triggers something called the after acquired evidence rule. Here's exactly how it works. Your employer fires you for an illegal reason, discrimination, wrongful termination, whatever it is. You hire a lawyer. The case is strong, but during the lawsuit, discovery happens. The company's lawyers get access to your text messages. They find the message where you asked your coworker to clock you in.
Even though that text had absolutely nothing to do with why they fired you, they can now say, "Well, if we had known this employee was committing time card fraud, we would have fired them for that." Courts allow this. The after acquired evidence rule lets employers use misconduct they discovered after the fact to limit your damages, cutting off your back pay, your front pay, your entire financial recovery. It effectively tells the court, "This was a bad employee anyway, we would have fired them eventually." A text you sent on a random Tuesday just became the thing that erased your compensation. The rule: never put a policy violation in writing, not even a small one, not even between friends. The rule that covers everything. Before we wrap up, I know exactly what you're thinking right now, but my coworker is my friend. They would never show those texts to my company. Here's what you need to understand about the legal process. Once a lawsuit is filed, both sides enter a phase called discovery. During discovery, the employer's lawyers can legally demand copies of all text messages relevant to your employment. It doesn't matter how close you and your coworker are. If the court orders those texts to be produced, they will be produced. Your coworker doesn't get to say no. The friendship doesn't protect you. Every joke, every complaint, every venting session you thought was private, all of it laid out on a conference table for lawyers to read. So here's the one rule that protects you from all 4 of these traps. Write every text to a coworker as if it will be projected on a screen in a courtroom. If that thought makes you uncomfortable, don't send it. Here's your recap. The 4 texts that can destroy your career and your legal case. Number 4, the awkward acknowledgement text. That laughing emoji just proved the harassment was welcome. Number 3, the job hunting text. You just killed your constructive discharge claim.
Number 2, the trash talk text. You just gave the employer their cover story. Number 1, the bend the rules text. You just handed them a reason to fire you that courts will accept even after the fact. The system counts on you not knowing how any of this works. Now you do. Protect your income, protect your case, and treat every single text to a coworker like it's evidence, because one day it might be. If this video helped you, smash that like button and subscribe. We drop new content every single week on exactly this kind of stuff. And drop a comment below. Has a text message ever gotten you in trouble at work? Tell me what happened. I read every single one. See you in the next one.
You're sitting in an HR office. Your manager's there. Someone from leadership is there. And they slide a piece of paper across the table. Look, we think it might be best if you resign. If you quit, it'll look better on your record. A termination could follow you. You're already exhausted. You've been dealing with this situation for months. The write-ups that came out of nowhere, the hours getting cut, the hostile environment nobody officially acknowledged, and now they're offering you a clean exit, a way to save face. So you sign. You go home, you file for unemployment. Denied. You quit voluntarily. You call a lawyer, they ask you what happened, you explain everything, the discrimination, the retaliation, the paper trail. The lawyer listens carefully and then says, "I'm sorry, the moment you signed that resignation, you gave up your wrongful termination claim. They knew exactly what they were doing when they handed you that paper." That conversation happens every single day across this country. Workers losing their legal rights, not because they did anything wrong, but because nobody told them what those rights were before it was too late. Today, we are fixing that. What's up, everyone? It's Saluna. Welcome back to Saluna versus the System, the channel where we break down the legal and workplace traps that cost workers thousands of dollars and years of their careers, so you can stop walking into them blind. Quick disclaimer, nothing in this video is legal advice. This is education only. Please consult an employment attorney in your state for advice specific to your situation. Let's get into all three. Mistake number 1, using PTO when you should be using protected medical leave. Here's a scenario that plays out constantly. You get injured, you have surgery scheduled, or a family member has a serious health condition and needs your care. So you do what feels responsible. You log into your company system and request paid time off. You think, I'm being a good employee. I'm using my own accrued time. I'm not causing problems. But here is what you actually just did. You gave up your legal protections. There's a federal law called the Family and Medical Leave Act, FMLA. It gives eligible employees up to 12 weeks of job-protected leave per year for qualifying health or family-related reasons. The critical word there is protected. When you are on FMLA leave, your employer cannot fire you for taking that time. They must hold your job. They must maintain your benefits. And if they retaliate against you for using that leave, you have a lawsuit. When you just use PTO, you get none of that. PTO is a company benefit, not a legal protection. Your employer can count those absences against you in a performance review. They can document attendance issues. They can use your time off as justification in a termination. And you generally have no retaliation claim because PTO carries zero federal protection. Here is the part that should make you furious. Many employers will let you burn through every hour of your PTO without ever telling you that you qualified for FMLA instead. They are not required to tell you. So you come to them and say, "I need time off for my surgery." And they say, "Sure, just put in a PTO request." They know you could have invoked federal protections, but why would they tell you that when it only benefits you? What to do instead? If your time off is medically related for yourself or a qualifying family member, do not just request PTO. Tell your employer in writing, "I need to take leave for a serious health condition and I would like to request FMLA leave." Get the FMLA designation on the record. That is what gives you legal protection. Also check your state laws. Many states have additional medical leave protections that go beyond federal FMLA. The point is the same regardless. If your leave is medically related, invoke your legal protections before you touch a single hour of PTO. Mistake number 2, doing an exit interview. You put in your notice. You're leaving.
HR reaches out and asks you to sit down for an exit interview. They frame it as a chance to give honest feedback and help improve the workplace. It feels harmless, maybe even cathartic. You finally get to say everything you've been holding back. Do not do this. Exit interviews do not help you. They help your employer. Here is exactly why. First, everything you say gets documented and goes into your personnel file. If you later bring a legal claim for discrimination, retaliation, or hostile work environment, your employer's lawyers will pull that exit interview and use it against you. Let's say the real reason you're leaving is discrimination, but in the exit interview you say something like, "I'm just ready for a new challenge," or "It felt like the right time." You just handed the defense their best piece of evidence. They will show that document to a jury and say, "Look, in her own words, nothing about discrimination." Second, exit interviews are designed to get you talking, and when people talk, they make admissions they don't realize they're making. You might minimize what happened because you're trying to be professional. You might contradict something you previously told a colleague. You might say something that undermines your future claim in ways you won't recognize until a lawyer points it out months later. Third, you have zero legal obligation to participate. None. It is not a legal requirement. It is not in your employment contract. Your employer cannot force you. You can simply say, "I appreciate the offer, but I'm going to decline." That is a complete answer. You don't owe them an explanation. If you have a potential legal claim, the last thing you should be doing is giving your employer a free deposition on your way out the door. If you want to hold them accountable, talk to a lawyer, not HR.
Mistake number 3, quitting when you should make them fire you. This is the one your employer will actively push you toward, and it is the most expensive mistake on this list. Here is the scenario. Things have deteriorated at work. Write-ups started appearing out of nowhere, your hours got cut, your manager is making your daily existence miserable, and then someone pulls you aside, HR, a manager, maybe even someone from leadership, and says, "Look, we think it might be best if you moved on. If you resign, it'll look much better on your record. A termination could really follow you." That is not advice. That is a trap. They are not looking out for you. They are protecting themselves. Here's what happens the moment you quit. You almost certainly lose your right to file a wrongful termination claim because you were not terminated. There's something called constructive discharge, which covers situations where conditions were so intolerable that any reasonable person would have been forced to quit. But constructive discharge has an extremely high legal bar. Your employer knows that. That is precisely why they prefer you to resign. You also lose unemployment benefits in most states. Voluntary resignation disqualifies you. That's money you are legally entitled to if you are fired, money that keeps you financially stable while you find your next position. Every unemployment claim costs your employer money. That's another reason they want your signature on that resignation letter. And the "it'll look better on your resume" line, that's fiction. Future employers almost universally verify nothing beyond your dates of employment and job title. They are using your fear of a termination on your record to get you to do the one thing that destroys your legal position. What to do instead? Do not quit. Make them fire you. If they fire you, you may have a wrongful termination claim. You likely qualify for unemployment benefits. And if they've been discriminating against you, retaliating against you, or violating the law in any way, their decision to fire you becomes the adverse employment action that completes your legal case. While you are still employed, document everything. Save every relevant email, write down dates, times, and exact words used in conversations. Build your record. And before you make any major decision, call an employment lawyer. That one phone call made before you sign anything or say anything is worth more than anything else you can do. Whatever you do, do not let your employer talk you into quitting. That decision should be yours. It should be strategic, and it should never happen under pressure in an office while someone is sliding a resignation letter across a table.
Here are the 3 mistakes that destroy your legal rights and what to do instead. Mistake 1, using PTO when you qualify for FMLA. Always invoke your protected leave in writing for any medically related absence. Mistake 2, doing an exit interview. Decline it. You have no obligation to participate. Mistake 3, quitting when your employer wants you gone. Make them fire you. Protect your claims and your unemployment eligibility. The system is designed to work against you in these moments because your employer has HR, legal teams, and years of experience navigating exactly these situations. What protects you is knowing your rights before the pressure hits. Now you do.
If this video helped you, smash that like button and subscribe. We drop content like this every single week. And drop a comment below. Has your employer ever tried any of these tactics on you? Tell me what happened. I read every single one. See you in the next one.
Imagine two candidates interview for the exact same position at the exact same company on the exact same day. The first one, let's call her Maya, walks in confident, prepared, answers every question cleanly. But at some point, the conversation gets comfortable and she starts opening up. She mentions she's been out of work for 3 months and really needs to get back. She talks about how her last boss was impossible to work with. She shares that her 5-year plan involves eventually starting her own business. And when the salary question comes up, she tells them exactly what she made at her last job. The second candidate, let's call her Zoe, covers the same ground, same qualifications, same experience level. But Zoe keeps every answer focused and strategic. She doesn't mention the toxic boss. She doesn't reveal the urgency. She doesn't disclose her previous salary. She gives them exactly what they need to evaluate her. Nothing more. Maya gets a rejection email 4 days later. No explanation, just, "We've decided to move forward with another candidate." Maya spent weeks wondering what went wrong. Her qualifications were solid. Her answers were honest. She was herself. That was exactly the problem. Not because being honest is wrong, but because in a job interview, what you reveal is just as important as what you say. And nobody ever told Maya which landmines she was walking straight into. Today, we're mapping every single one. What's up, everyone? It's Saluna. Welcome back to Saluna versus the System, the channel where we give you the insider information the system never hands you, your career, your money, and how to stop making expensive mistakes that look completely innocent on the surface. Today, we're talking about 8 things you should never reveal in a job interview, straight from someone who has sat on the other side of the table and watched great candidates eliminate themselves with information they never needed to share. This is not about lying. This is about being strategic. There is a difference. Let's get into every single one. Number 1, too many personal details. The first mistake is one of the most common, oversharing personal information because you're nervous or because the conversation feels comfortable and friendly. Here's what recruiters and hiring managers actually observe when this happens. They connect your ability to communicate concisely in an interview directly to how you would perform in a business setting. If you're in sales and you ramble in front of a client until their eyes glaze over, you're not closing the deal. If you're in management and you can't deliver a focused update, meetings become painful. The interview is the sample. Your answers are the product. The general rule is 2 to 3 minutes maximum per interview answer. If you're going beyond that regularly, you are losing them, and you may not even know it. And beyond length, oversharing personal details creates another risk. The person listening will form opinions, consciously or not, based on information that has nothing to do with your ability to do the job. A hobby they don't relate to, a lifestyle detail they weren't expecting. Any of it can create bias. Keep everything anchored to the role. Personal details belong outside that room. Every interviewer is going to ask some version of this question, and the temptation to be fully honest, to say your boss was impossible, the company treated you badly, the work was soul-crushing, is very real, especially if all of that is true. Here is the problem. The moment you say, "My manager was terrible and we constantly butted heads," what the interviewer hears is, "This person might be difficult to manage." When you say, "I was bored and not challenged enough," what some hiring managers hear is, "This person didn't go out and create their own opportunities." This is not fair. It is simply how it works. Your job is to take the real reason you're leaving and reframe it in terms of what you're moving toward, not what you're running away from. "I'm looking for an environment where I can contribute at a higher level," lands completely differently than "I couldn't stand my last manager." Same truth, completely different signal. Number 3.
your long-term plans to leave the industry or start a business. Interviewers will ask where you see yourself in 5 years, and if your honest answer is, "I plan to start a business," or "I'm thinking about switching careers entirely," that answer is going to cost you the offer in most cases. Here is why. When you reveal plans that take you completely away from the type of work you're interviewing for, you are telling the hiring manager you're not actually passionate about this role. You're using it as a stepping stone for something else entirely. And companies invest significantly in new hires, onboarding, training, ramp-up time. They want to believe the person they're hiring wants to be there. If you have plans to eventually build something of your own, which is completely legitimate and admirable, keep them private during the interview process. Talk about growth within the field you're interviewing for. The business dreams stay in your personal conversations. Number 4, that you're desperate or urgently need the job. You got laid off, you're burning through savings, you need to start collecting a paycheck as soon as possible. The urgency is real and completely understandable. But if that urgency bleeds into your interview through rushed energy, overeagerness, or directly telling them you need this job quickly, it works against you almost every time. Think about how it reads from the other side of the table. Desperation signals that your primary motivation for wanting this specific role is financial pressure, not genuine fit or interest. And that raises questions. Will they leave the moment a better option comes along? Are they settling? Is this role actually right for them? Reach down and project calm, focused confidence, regardless of what's happening externally. The interview is a performance in the best sense of the word. You are presenting the most composed, strategic version of yourself. Save the real story for people who already know you. Number 5, your age in either direction. Age discrimination is illegal under federal law. It also happens constantly, in both directions. Candidates perceived too young and candidates perceived too old both face bias that is real, documented, and very difficult to prove. You are not required to disclose your age at any point in the interview process, but there are ways people inadvertently signal it without realizing. An email address that includes your birth year, a resume that lists graduation dates going back 35 years, technology references that date you, mentioning how many years you have left before retirement. Keep graduation dates on your resume to the last 15 years of experience. Update your email to something clean and professional, and do not volunteer any information about where you are in your career timeline. Let your qualifications speak without the age attached.
Number 7, how many years you have left in the workforce. This one is specifically for candidates in the final stretch of their career, typically the last 5 to 10 years before retirement, and it is one of the most common and costly mistakes in this demographic. Saying something like, "I just want one last good role before I retire," or "I'm looking to put in my final 10 years somewhere solid," even though it sounds honest and reasonable, immediately creates bias in a hiring manager's mind. They start calculating. They start thinking about succession planning. They start wondering if this person is going to grow with the role or just occupy it. None of that calculation benefits you. Keep the focus entirely on what you bring and what you want to contribute, not on the timeline of your exit. Number 7, medical conditions or disabilities that aren't relevant to the role. You are not legally required to disclose a disability or medical condition during the interview process. The Americans with Disabilities Act protects you from discrimination based on disability, and that protection only works if you don't volunteer information that creates bias before an offer is made. If you require a reasonable accommodation to perform the job, the appropriate time to raise that is at the offer stage, not during the interview itself. The interview is for evaluating fit based on qualifications. Disclosing medical information before an offer introduces variables that should not influence the hiring decision, but in practice sometimes do. The one exception, if a condition directly prevents you from meeting the core requirements of the role as described in the job posting, that is a different conversation. But for anything that falls under reasonable accommodation, wait until the offer. Protect yourself. Number 8, your previous salary.
This is the final one and arguably the most financially consequential on this list. When you disclose your previous salary, you hand the employer a starting point for their offer, and that starting point is almost always lower than what the market would otherwise support, especially if you were underpaid at your last role, which is more common than most people realize. You are not obligated to share your previous compensation in most states. When the salary question comes up, redirect to the market. Based on my research and the scope of this role, I'm targeting a range of X to Y. That is a market-anchored answer that opens a real negotiation. Disclosing your old salary anchors the conversation to your past, which benefits the employer, not you. Your value is determined by what the market pays for your skills, not by what your last employer decided you were worth. Here is your full list: 8 things to keep out of the interview room. Too many personal details, the full unfiltered reason you're leaving, your plans to exit the industry, any desperation or urgency, your age in either direction, how many years you have left, medical conditions that aren't directly relevant, and your previous salary. None of this is about being dishonest. It is about understanding that the interview is a strategic presentation, not a therapy session, not a confessional, not a casual conversation between friends. Every piece of information you share either moves you forward or creates a reason to filter you out. Be prepared, be focused, be strategic. Give them exactly what they need to say yes, and nothing that gives them a reason to say no. If this video helped you prep for your next interview, smash that like button and subscribe. We drop new content every week on your career, your money, and how to stop leaving opportunities on the table. Drop a comment below. Which of these have you made before? I read every single one. See you in the next one.
Picture this. It's a Tuesday morning. You're sitting in your car in the parking lot before work. Engine off, hands still on the wheel. You've been sitting there for 6 minutes. Not because you're early, because you can't make yourself go inside yet. The last 3 months have been brutal. Your manager keeps moving the goalposts, a coworker left and nobody replaced them. You've been carrying double the workload at the same pay with the same title and 0 acknowledgement. And today you finally decided to do something about it. Because someone told you, just go talk to HR. That's literally what they're there for. So you took a breath, you grabbed your bag, you walked in. And for the first time in months, you felt something close to hope. You sat down across from the HR rep, someone you've always found warm, approachable, genuinely kind, and you just opened up. You talked about your manager, you talked about the workload, you talked about how invisible you've been feeling. You said the thing you'd been holding in for months. I just needed someone to finally hear me. And they nodded. They handed you a tissue. They said all the right things. You walked out of that office feeling lighter than you had in months. 3 weeks later, you were called into a meeting. Your manager was there. HR was there, and on the table with your name printed at the top was a performance improvement plan. You didn't get help that day. You built your own case file, and nobody warned you. What's up, everyone? It's Soluna from Soluna versus the System. Today, we are going into a room that most people think is safe and exposing exactly why it isn't. We're talking about HR, human resources, the department that exists at every company, that presents itself as a neutral support system, and that most employees trust by default. By the end of this video, you will never walk into that office the same way again, because there are 10 specific things people say to HR every single day, things that feel completely reasonable, even necessary to say, that quietly get used against them. Let's get into it. Part 1. The truth about HR that nobody tells you. Before we get into the list, I need to give you the foundation, because once you understand this one thing, everything else will make complete sense. HR is not on your side. I'm not saying that to be dramatic. I'm not saying HR people are evil, or that everyone who works in HR has bad intentions.
A lot of HR professionals are genuinely warm, caring, and well-meaning people. But here's the reality that does not change no matter how nice the person across from you is. HR exists to protect the company, not you, the company. Think about it. Who pays HR? The company. Who does HR report to? Leadership. Whose interests does HR exist to serve at the end of every single workday? The organization. And that means every single thing you say inside that office gets filtered through one question. Not, is this person hurting? Not, is this fair? Not, how do we make this better for this employee? The question is this a risk to the company? That's the filter. That's the only filter. And once you truly internalize that, once it stops feeling like a cynical take and starts feeling like the practical reality it is, you will stop walking into that office hoping to be understood and start walking in knowing exactly what game you're playing. Now, let's talk about the 10 things you should never say to HR.
Number 1, I hate my manager. I know. Some managers genuinely deserve it. Some of them are truly terrible, micromanaging, credit-stealing, direction-changing nightmares who make your professional life miserable every single day. But the second those words come out of your mouth in an HR conversation, something shifts. You stop being the person with a legitimate problem. You become the problem. HR doesn't go home thinking about your suffering. HR goes home thinking about how to resolve the conflict. And the fastest, cleanest way to resolve a conflict is to manage the person who raised it. You become a file, a situation, a liability to be contained. What to say instead? I'm having some challenges working with my manager, and I'd like to talk through some solutions. Same issue, completely different outcome. One makes you sound like a complaint, one makes you sound like a professional.
Number 2, this isn't fair. Of course it's not fair. A lot of things that work aren't fair. But here's the problem. Fair is an emotion, and emotions without structure make you look reactive, not credible. HR doesn't operate on the principle of fairness. HR operates on the principle of policy, rules, documentation, process. So instead of saying this isn't fair, which tells them nothing actionable, ask which policy or process was used to make this decision. That question does the exact same thing. It challenges the decision, but now you sound like someone in control, not someone who's upset. Number 3, I've been so stressed and anxious. And this one I want to handle carefully, because your stress is real, your anxiety is valid. 83% of American workers report experiencing work-related stress. You are absolutely not alone in this. But when you say it to HR without structure, without a specific ask, without framing, it quietly becomes evidence. Evidence that you're struggling to handle your responsibilities. Evidence that builds a picture, not the one you meant to paint, but the one they're allowed to paint with what you gave them. What to say instead is, the current workload has created some real capacity issues. I want to talk about how we can prioritize more effectively. Same problem, but now you're a professional identifying a business issue, not someone falling apart in the HR office. Number 4, I don't get paid enough. Possibly the truest sentence in this entire video. Most people don't get paid enough. That is a statistical fact. But walking into HR and saying that without preparation is like walking into a negotiation having already shown your hand. You've given up all your leverage before the conversation even starts. What to say instead is, I'd like to schedule time to discuss my compensation based on my contributions and current market data. That sentence opens a negotiation. The other one opens a complaint file. My coworker told me, the moment another person's name comes out of your mouth in an HR meeting, you have just made everything significantly more complicated. Now HR has to think about your coworker. Now you look like someone connected to office gossip, even if everything your coworker told you is completely true. Even if it's important, even if it directly affects your situation. The rule is simple.
only speak to what you personally witnessed. First-person observations only. Keep other people's names out of it entirely.
Number 6, off the record. There is no off the record in HR. I need you to really hear that. There is no casual chat. There is no just between us. HR professionals are often legally required to document certain disclosures. An informal comment you throw in at the end of a meeting can become a formal record. When you say off the record, you think you're protecting yourself. You're actually giving them more, because now they have both the official version and the unguarded version. The rule, if you wouldn't want it to see it written down in a document with your name on it, don't say it.
Number 7. I'm looking for another job. People say this thinking it creates urgency, thinking the company will suddenly realize how valuable they are and respond accordingly. Sometimes that works. Most of the time, the moment you signal that you might be leaving, the company quietly stops investing in your future there. Why put you in the leadership development program if you might be gone in 90 days? Why fight for your raise in the budget meeting? Why give you the high visibility project? Keep your job search private. Always, especially when it's true, especially when it's going well. Number 8, I don't trust leadership. This one gets you flagged instantly. And I understand why people say it. Sometimes leadership genuinely cannot be trusted. Sometimes the culture at the top is exactly as broken as it looks from the bottom. But HR works for the organization that leadership built. Telling HR you don't trust leadership is like complaining to someone's best friend that you don't like them. You are not going to get sympathy. You are going to be reported. What to say instead is, I want to make sure I understand the direction we're heading so I can stay aligned and contribute effectively. Same underlying concern, 0 red flags, 0 profile.
Number 9, I just needed to vent. HR is not where you vent. HR is where things get recorded. The moment you say, I just needed to vent, you have just told them that everything you said before that sentence was emotional rather than factual. Your feelings just became your professional reputation. If you need to vent, and we all do, it's human, it's necessary, call a friend, talk to your partner, see a therapist, process it somewhere that doesn't have a filing system, just not in that office. Number 10, I'm going to sue. I know exactly why people say this. When you feel completely powerless, when nothing else has worked, when you've tried everything and the situation is still getting worse, this feels like the one card you have left. But the moment those words leave your mouth, the conversation stops being human. It becomes legal. HR can no longer engage informally. Every word gets measured. Every response gets reviewed. Any chance of resolving things quietly, privately, without permanent consequences disappears completely the moment that sentence lands. If you genuinely believe you have a legal case, talk to an employment attorney first, before you say a single word to HR. An attorney can tell you what you have, what you need, and exactly how to protect yourself. Say it without that preparation, and you lose the moment you open your mouth. Part 3. The pattern underneath all 10. Did you catch it? Every single one of those 10 things has the same core problem underneath it. Honest feelings with no strategy. Real pain with no plan. And here's the important part. None of that is your fault. Nobody sits you down before your first job and says, by the way, HR is not your friend. Here's how to talk to them without hurting yourself. Nobody explains that the most dangerous thing you can sometimes do at work is simply be honest without thinking carefully about who is listening and what they're allowed to do with what you say. The lesson is not to stop being honest. The lesson is to be smart about where you put that honesty and who receives it and how it's framed when it leaves your mouth. Because at work, truth without a plan can cost you everything.
So, what do you actually do? Here's the exact 3-step framework. Step 1, speak in facts, not feelings. Not, I feel like this situation is completely unfair. But,
This decision was made without the evaluation criteria being clearly communicated to me. Can we walk through that process together? Same concern, completely different professional profile. Step 2, always have a specific ask. Know what you want to walk out with before you walk in, not just a problem, a requested outcome. I'd like clarity on X. I'd like to understand the process for Y. I'd like to discuss options for Z. A specific ask makes you look solution-oriented. Vague frustration makes you look like a risk to be managed. Step 3, write it down before you go in. 3 things on paper before that meeting starts. 1, what specifically happened. 2, what outcome you are requesting. 3, what you will say if the conversation goes somewhere unexpected. 3 sentences. That's the difference between walking in vulnerable and walking in prepared. And that difference, it can determine the entire trajectory of what comes next. Part 5. Back to Ashley. Remember Ashley from the beginning? 9 years at the same company, good at her job, shows up, delivers, gives everything she has. She didn't lose because she wasn't good enough. She lost because she walked into that office open, unguarded, and completely unprepared. She said real things, true things, things that genuinely needed to be said. But she said them without a plan, without a specific ask, without thinking about who was really sitting across from her and what that person was actually allowed to do with everything she shared. And every word she said, every honest, vulnerable, heartfelt word got used. The opposite of what happened to Ashley is not dishonesty. It is simply being prepared.
Part 6, the bigger picture. And here's what I want you to take away from all of this. Not just the list, not just the tactics, but the bigger truth underneath everything. The workplace is a system, and like any system, it has rules that are written down and rules that are never written down anywhere. The written rules, those are in your employee handbook, your contract, your company's official policies. The unwritten rules, those are what we talk about on this channel. The unwritten rule about HR is this: that office is not a safe space. It is a processing center. And the most powerful thing you can do for your career, for your income, for your peace of mind, is learn how to navigate that processing center like someone who knows exactly what it is. Not angry, not bitter, not paranoid, just prepared. Because the people who thrive long-term in professional environments are not the ones who trust blindly or the ones who trust no one. They're the ones who know exactly which rooms are safe and which ones require a different level of awareness. You just learned the difference. Ashley went in to get help. She left with a target on her back. Not because she lied, not because she did anything wrong, because she was honest in a room that was never designed to protect her honesty. Now you know something she didn't know when she walked through that door. So here's my question. Drop it in the comments right now. Have you ever said something to HR or at work and later realized it changed how people treated you? What happened? I read every single comment, and I promise someone reading your comment is going to recognize their own story in it. If you know someone who is about to walk into an HR meeting thinking it's a safe place, send them this video today, before they walk in that door, because one conversation can change everything. And if you want to keep learning the rules of the game that nobody puts in the employee handbook, subscribe right now, because we are just getting started. I'm Saluna. I'll see you in the next one.
One wrong move after 50 can destroy decades of savings. Not a series of bad decisions, one move, one moment of greed, one time you told yourself, I just need one last big gain. I have seen it happen. A successful person, smart, disciplined, who saved for 30 years. They get to their 50s, their nest egg is substantial. But they look at the market and they see others getting rich. They see crypto up 500%. They see tech stocks soaring. They see real estate flipping fortunes. And they think, why not me? I have earned this. I deserve a piece of that. So they take a chunk of their savings, money they cannot afford to lose, and they put it into something risky, something that promises big returns, something that feels like their last chance to really win. And then the market turns, or the stock crashes, or the crypto exchange collapses. And just like that, years of savings are gone. Not slowly, not gradually, overnight. And at 55, you cannot get those years back. You cannot work another 30 years to recover. That money is gone, and so is your retirement. Today, I'm going to tell you the one thing you should never do with your savings after 50. I'm going to explain why it is so dangerous, and I'm going to show you what to do instead. At this stage of life, your financial decisions matter more than ever. When you're 25, you can make mistakes. You can lose money in a bad investment. You can speculate on something silly. You have 40 years to recover. 40 years of earning, saving, and compounding. A loss at 25 is a learning experience. At 55, you do not have 40 years. You have 10 or 15 years until retirement, maybe less. A loss at 55 is not a learning experience. It's a disaster, because you don't have time to rebuild. You don't have time to wait for the market to come back. You don't have time to earn back what you lost. The mistake I see most often is putting too much money in risky investments because you want one last big gain. It's the retirement equivalent of a Hail Mary pass. You're losing, the clock is running out, so you throw the ball as far as you can and hope for a miracle. But investing is not football, and Hail Marys almost never work. What actually happens is you take a risk that you don't need to take, you lose money that you cannot afford to lose, and you spend the rest of your life regretting one stupid decision. Let me explain why this mistake is so dangerous for people over 50. It's not just about the money. It's about 3 things that change as you get older. First, you have less time to recover losses. This is the most obvious, but also the most important. A 30-year-old who loses 50% of their portfolio still has 30 years of contributions and compounding ahead of them. A 55-year-old who loses 50% of their portfolio may be 10 or 15 years. The math is brutal. To recover a 50% loss, you need a 100% gain. A 30-year-old might see that over decades. A 55-year-old almost certainly will not. Second, market crashes hit harder when you're closer to retirement. A crash when you're 30 is a buying opportunity. You keep contributing, you buy more shares, and you come out ahead. A crash when you're 55 is terrifying. You don't have as much time to wait for the recovery. You might be forced to sell at the worst possible moment just to pay your bills. That is not a buying opportunity. That is a financial disaster.
Third, emotional decisions increase as you get closer to retirement. The stakes feel higher. The fear of not having enough is real. And that fear makes you do stupid things. You chase returns. You follow tips from friends. You invest in things you do not understand. You take risks that your younger self would have laughed at because you feel the clock ticking, because you want to make up for lost time, because you are afraid. And here's the cruel irony. The very fear that drives you to take risks is the thing that makes you most vulnerable to losing everything. You're not making rational decisions. You're making desperate decisions. And desperation is expensive. Here's a simple explanation that everyone over 50 needs to hear. At 25, you can recover from mistakes. At 55, you often cannot. That's not pessimism. That's math. When you're 25, your human capital is massive. You have decades of future earnings. Your investment portfolio might be small, but your ability to earn is huge. A loss hurts, but you can work more, save more, and make it back. When you're 55, your human capital is limited. You're near your peak earnings, but you don't have decades left.
A loss doesn't just hurt, it changes your life. It might mean working 5 more years instead of retiring. It might mean a smaller retirement. It might mean no retirement at all. That's why the rules change after 50. What was smart at 30 is reckless at 50. Speculating on individual stocks, betting on crypto, leveraging your portfolio, chasing the next hot sector. Those are young people's games. At 50, you don't need a home run. You need base hits. You need singles and doubles. You need to get on base without striking out. Because striking out at 55 means something different than it did at 25. At 25, strike 3 means you go back to the dugout and wait for your next at-bat. At 55, strike 3 might mean the game is over. So what should you do instead? The fix is not complicated, but it requires a shift in mindset, a shift that many people resist because it feels like giving up. After 50, your focus needs to shift to 3 things: stability, income generation, and capital protection. Stability means your portfolio should be boring, not exciting, not cutting edge. Boring. Think broad market index funds. Think diversified bonds. Think asset allocations that have worked for decades. Boring portfolios don't make you rich overnight, but they also don't make you poor overnight. And at 50, not getting poor is more important than getting rich. Income generation means you start thinking about cash flow instead of growth. Dividends, interest, rental income, money that shows up every month whether the market is up or down. Income-generating assets aren't as glamorous as growth stocks, but they pay your bills, and paying your bills is the whole point of retirement. Capital protection means you stop gambling and start insuring. You keep an emergency fund. You avoid leverage. You say no to investments that promise high returns with low risk, because those don't exist. You accept that you will not beat the market. And you realize that's perfectly fine. You don't need to beat the market. You need to not lose. Here's a concrete example. Instead of putting $50,000 into a speculative tech stock, you put it into a diversified portfolio of 60% stocks and 40% bonds. That portfolio might return 6 to 8% over time. Not exciting, but also not zero. Over 10 years, that $50,000 grows to $90,000 or $100,000, safely, predictably, without sleepless nights. Instead of chasing crypto, you max out your Roth IRA. Instead of options trading, you pay down your mortgage. Instead of a Hail Mary, you take the field goal. Points are points, and field goals win games.
Let me bring this all together. After 50, protecting money becomes more important than growing it fast. That is not a popular thing to say. Everyone wants to get rich. Everyone wants one last big win. But the people who actually succeed in retirement are not the ones who took the biggest risks. They are the ones who avoided the biggest mistakes. One wrong move after 50 can destroy decades of savings. Putting too much money in risky investments because you want one last big gain is that wrong move. You have less time to recover. Market crashes hit harder. Emotional decisions increase. The math is against you. The solution is to shift your focus: stability over excitement, income over growth, protection over speculation, boring portfolios that work over exciting bets that probably will not. You do not need a miracle. You need a plan. You need discipline, and you need to accept that the game has changed. At 25, you were playing offense. At 55, you played defense, and defense wins championships. Most people only realize this after they have lost money they cannot get back. You just heard it in time. Imagine you're 3 years into a job you genuinely like. You've got a manager who feels different from the managers you've had before, warmer, more present, the kind of person who actually remembers what you told her last week. She asks how your weekend was and actually listens to the answer. She remembers your dog's name. When your performance review comes around, she always finds something specific and kind to say, not the generic corporate language most managers default to. Over the years, in the small, comfortable moments, grabbing coffee before a meeting, walking out together after a long day, the 5 minutes before a call starts when everyone's waiting for one more person to join, you've told her things. Not anything dramatic, not a confession, just the normal texture of being a person. You mentioned you and your partner are thinking about starting a family in the next year or two. You mentioned once, almost in passing, that money's been a little tight since you bought the house. You mentioned you've been more tired than usual lately. And when she asked if everything was okay, you told her, honestly, because she seemed to genuinely care, that you'd been dealing with some anxiety, that you'd started therapy, that it was something you were working through. None of it felt risky in the moment. It felt like exactly what a good professional relationship is supposed to feel like. Human, real, trusting. 18 months later, you notice something. The high-visibility project that came up last quarter, the one that would have been a natural fit for you, went to someone else on the team. The promotion conversation that should have happened this cycle got quietly pushed to next year when the timing's better. You weren't looped into a strategic planning session you would have expected to be part of. None of these things, taken individually, raised any alarms. Each one came with a perfectly reasonable explanation. Different team needs, better fit, timing. But something in you, some quiet, persistent feeling, knows that something has shifted. You just can't point to the moment it happened. You can't draw a straight line from any single event to any single cause. Here's the uncomfortable truth nobody tells you when you start your career. The line exists. It's just invisible. And it usually starts in exactly the kind of conversation that felt the safest, the one where your guard was down, the coffee was warm, and the person across the table seemed like more of a friend than a manager. Hey everyone, it's Saluna. Welcome back to Saluna versus the System. Today's video is a long one, and I think it might be one of the most important things I've covered on this channel. We're talking about the 7 categories of personal information you should never share with your manager, not because they're bad people, not because sharing makes you weak, but because of how human cognition actually works, how managerial decision-making actually functions, and how the cost of oversharing compounds silently over years. By the end of this video, you're going to see your workplace relationships completely differently. Let's get into it. Before we get into the 7 specific categories, I want to slow down and actually explain the mechanism behind all of this, because if you don't understand the mechanism, the rest of this video is just going to feel like paranoid advice. It's not paranoid, it's structural, and once you see the structure, you can't unsee it. Here's the core idea. The relationship you have with your manager is real. I'm not telling you to treat your manager like an adversary, or to assume bad faith, or to wall yourself off emotionally from someone who might genuinely like you and care about your well-being. Most managers are not villains. Most of them are decent people trying to do a hard job reasonably well. The warmth in the relationship is often completely genuine.
But underneath that warmth, your manager occupies a structural role that requires them to make a continuous stream of decisions about you. Who gets which project? Who gets recommended for which opportunity? Who gets the benefit of the doubt when something goes wrong? Who gets considered for promotion this cycle versus next cycle? Who gets pulled into the room when leadership is discussing the team's future? Every one of these decisions requires your manager to draw on some internal model of who you are, your reliability, your trajectory, your risk profile, your likely future with the company. Here's the part that matters most. That internal model isn't compartmentalized. There is no separate file in your manager's brain labeled "personal information, do not use for professional judgments." Human cognition doesn't work that way. It's integrative. Everything they know about you, your work output, your communication style, and yes, the personal things you've told them, gets folded into one continuous, evolving picture. And that picture is what gets consulted, consciously or not, every time a decision about you needs to be made.
This is not a story about dishonest managers deliberately weaponizing your secrets. It's a story about a basic feature of human memory and judgment. Once you know something, you cannot unknow it. The thing you told your manager in March about your plans to start a family is still sitting in the picture they hold of you in October, even if they never consciously think about it again. It's there. It's part of the texture. And when they're sitting in a calibration meeting discussing year-end ratings or a leadership conversation about who's ready for more responsibility, that texture quietly nudges the outcome, even though almost nobody in that room, including your manager, would consciously cite it as the reason. This is why most people never make the connection between what they shared and what happened to their career. The effects rarely show up immediately. They surface months or years later in decisions explained using completely different language. Better fit for the role, different team needs. We want to bring in someone who can really commit to the long-term vision here. Nobody says, "We didn't promote you because you mentioned 6 months ago that you might want to scale back once you have kids." That sentence never gets said out loud, not because people are hiding it maliciously, but because by the time the decision gets made, the connection between the original disclosure and the eventual outcome has dissolved into a general impression. The impression feels like an objective read on you. It is, in fact, partly built from things you said when you weren't thinking strategically at all. Now let's go through the 7 categories. I want to spend real time on each one because the specific mechanics differ slightly, and understanding each mechanism is what actually protects you, not just a vague sense that you should be careful. Category 1, your future plans to leave or scale back. This is, in my experience, and in the experience of almost everyone who's studied workplace dynamics seriously, the single most expensive category of disclosure. And it's also one of the most tempting to share, because the impulse behind it usually feels genuinely good. A desire to be transparent, to give your manager fair notice, to not blindside them down the road. You tell yourself, "I'm being a considerate employee. I'm giving them time to plan. This is the right thing to do."
Here's what actually happens once that information lands. The moment your manager knows, even vaguely, even with no firm date attached, that your time at the company has a foreseeable horizon, every subsequent decision about you starts running through that lens, whether they intend it to or not. Let's make this concrete. A high-visibility, multi-year strategic initiative comes up. It needs someone who can own it from inception through execution, 18 months, 2 years, sometimes longer. Your manager has 2 people in mind who could technically do the work. One of them mentioned 4 months ago that they're hoping to start a family soon and might want to step back from some travel-heavy responsibilities. The other one hasn't said anything like that. Even if your manager genuinely believes you're the stronger candidate technically, the calculus shifts. Why invest the visibility, the political capital, the developmental energy into someone whose long-term trajectory with the company is uncertain when there's a viable alternative whose runway looks more secure? This is not your manager being cruel. This is your manager doing exactly what their role requires them to do, allocating scarce, valuable opportunities to the people who represent the most reliable return on that investment. Knowing about your plans doesn't make them think less of you as a person or professional. It just changes the math in a very specific, very predictable way. The same logic plays out with promotions. A promotion is structurally an investment decision. The company is betting that putting more responsibility, more compensation, and more visibility into you will pay off over a multi-year horizon. If your manager has reason to believe, even just a vague impression, even something they couldn't fully articulate if asked, that your runway might be shorter than someone else's, the promotion quietly gets pushed. Let's revisit this next cycle. I want to see a little more runway in this role before we move you up. These explanations sound completely reasonable on their face. They might even be partially true, but underneath them is often a calculation that started the day you mentioned your plans over coffee. I want to be very clear about something here, because this is an important distinction. This is not me telling you that wanting a family, wanting more balance, wanting to eventually do something different with your life is wrong, or that you should feel ashamed of those desires. The opposite is true. Your life outside work matters more than your job. Full stop. What I'm telling you is that the timeline of those plans does not need to live inside your manager's working model of you before it's operationally necessary. There's a massive difference between informing your manager of a concrete near-term change. I'm going on maternity leave in March. Here's the plan. Which is necessary, appropriate, and often legally protected information, and casually mentioning a vague, distant intention. We're thinking about starting a family sometime in the next couple of years, which serves no operational purpose for them, but quietly reshapes how they see your future at the company starting that day. The rule of thumb: share what they need to know when they need to know it in the form they need it. Don't share the internal narrative of your life plans before there's an operational reason to. Category 2. Details about your financial situation. This is the category most people don't even realize they're disclosing because it almost never comes out as a direct statement. Nobody walks into a one-on-one and announces their bank balance. It comes out in fragments, scattered across dozens of completely normal conversations over months and years. You mention you just closed on a house and the mortgage is a little more than you'd hoped. You mention your partner got laid off and is between jobs right now. You mention child costs more than you expected. You mention you're saving aggressively for something specific, a wedding, a down payment, your kid's education. Any single one of these, said in isolation, is nothing. It's just normal small talk, the kind of thing people share to build rapport and feel like real humans to each other.
But your manager's brain doesn't process these as isolated data points. Over time, they accumulate into a composite picture, and that picture, once formed, becomes a quiet, persistent input into how your manager approaches almost every interaction with you that touches on money, risk, or negotiation. Here's where it actually costs you. When you ask for a raise, your manager, consciously or not, remembers the mortgage, the tight budget, the financial pressure you've described over the past year. That memory doesn't necessarily make them want to give you less, but it does shape their confidence about how hard you'll push back if the number comes in lower than you'd hoped. It shapes their read on how much leverage you actually have or believe you have. People with visible financial flexibility get treated, in negotiation, as people who might walk away if the offer isn't good enough. People whose financial constraints are visible get treated as people who are more likely to accept whatever's offered, because the alternative, pushing back hard, risking the relationship, potentially looking for something else, carries more downside for them personally. The same dynamic plays out when a difficult, undesirable assignment needs to be handed out. If your manager has a mental picture of you as someone under financial pressure, they may, again, not necessarily out of malice, assume you're more risk-averse, less likely to push back, less likely to leave even if the assignment is unpleasant. You become, in a quiet and unspoken way, a safer person to load extra work onto. And when restructuring conversations happen, when leadership is discussing who might be vulnerable to layoffs, who might be a flight risk, who's likely to stay regardless of how they're treated, your financial picture, assembled entirely from things you said in passing, becomes part of the silent calculation. Managers are sometimes consciously aware they're factoring this in. Often they're not. It's simply baked into their overall sense of who you are and what your options look like. The protective move here isn't to become evasive or paranoid about every mention of money. It's to recognize that the accumulation matters more than any single comment. A single mention of a tight month is forgettable. A consistent pattern of financial detail over years builds a picture that's very hard to undo, because nobody consciously decides to build it. It just happens, conversation by conversation, until it's complete. Category 3. Ongoing health issues, especially chronic illness and mental health.
This is the hardest one to talk about honestly, because the disclosure almost always happens in good faith, and the consequences are genuinely uncomfortable to acknowledge, both for the person sharing and for the manager receiving it. Let's say you've been dealing with anxiety or a chronic illness, or you've recently started therapy, or you have a condition that flares up unpredictably and affects your energy and focus. You mention it to your manager, maybe because they asked if you were okay, maybe because you wanted to explain a rough patch, maybe because it just felt natural in a moment of real conversation. Your manager may respond with genuine warmth. They may say all the right things. They may even, in the short term, become more accommodating, give you a little more flexibility, check in more thoughtfully. None of that prevents what happens next, which is quiet and almost impossible to trace. Once your manager knows about a health condition, the information becomes part of how they interpret everything you do going forward. This is the integrative nature of cognition again. It doesn't get filed away separately. Your tiredness on a Tuesday afternoon, which used to register as nothing at all, now registers as a possible symptom. A moment of pushback in a meeting, which would have read as normal professional disagreement from anyone else, gets quietly filed as a possible flare. A genuinely bad day, the kind everyone has occasionally, starts to look, in your manager's evolving picture of you, like part of a concerning pattern rather than an isolated event.
I want to be precise here, because this matters legally and practically. The legal protections around medical information and disability are real, and they protect you against explicit discrimination, against someone refusing to hire you, fire you, or deny you a promotion because of a documented medical condition. What those protections cannot do is prevent the slow, undocumented drift in how someone perceives your reliability over time. Nobody writes passed over for promotion due to mental health disclosure in any record anywhere. The recalibration happens silently, in the manager's own evolving assessment of how dependable you'll be over the coming years. A recalibration they likely couldn't even articulate honestly if you asked them directly, because it's not a conscious, deliberate bias. It's an unconscious drift in perception that happened the moment they learned something they can't unlearn. This is genuinely one of the most painful asymmetries in this entire video, because the instinct to share, to be honest about a real struggle, to ask for understanding, to not pretend everything is fine when it isn't, is a healthy instinct in almost every other context of life. The workplace is one of the few environments where that healthy instinct can quietly work against your long-term interests, even when the person receiving the information genuinely cares about you. The practical guidance here is not to suffer in silence or to deny yourself necessary accommodations. If you legitimately need a formal accommodation, modified hours, equipment, leave, that conversation should happen through the appropriate formal channel, often with HR involved, specifically because that channel comes with actual legal protection attached to it. What I'm cautioning against is the casual, ongoing disclosure of health struggles in informal conversation with your direct manager, where the information enters their general impression of you without the protective structure that a formal accommodation process provides. There's a real difference between I have a documented need that requires this specific accommodation and I've just been really anxious lately, work has been a lot. The first is structured and protected. The second floats freely into the manager's evolving picture of your reliability with no formal protection attached to it at all. Category 4. Conflicts in your personal life. This category covers the kind of personal turbulence almost everyone experiences at some point: divorce, custody disputes, friction with siblings, a difficult or unwell parent, a painful breakup, a falling out with a close friend. The impulse to share comes from a completely understandable place. You're going through something hard, you need support, and a kind manager who seems to genuinely care often invites exactly this kind of disclosure without meaning to extract anything from it. The cost shows up later, and it shows up in a specific, recognizable way. Once your manager has heard about significant turbulence in your personal life, they start to unconsciously categorize you as someone currently navigating instability. And people who are read as navigating instability tend to not get the assignments that require a particularly steady hand under pressure. They tend to not get the promotion into the role that demands visible composure in difficult moments. They tend to not get the high-stakes client relationship, the board presentation, the crisis response team. Not because anyone consciously decides this person is too unstable for this, but because when a list of candidates is being assembled for something that requires unwavering steadiness, the unconscious mental shortlist quietly excludes the person whose personal life was recently described as turbulent. What makes this category particularly insidious is the timeline mismatch. Your personal crisis might resolve in 6 months. The divorce finalizes. The custody arrangement settles into a routine. The relationship with your sibling repairs itself, or you simply make peace with the distance. From your perspective, the turbulence is over, and you're back to your normal, steady self.
But the adjustment your manager made to their internal model of you doesn't automatically reset on the same timeline. The picture they built during your difficult period tends to persist well past the point where the difficulty itself has resolved, because nobody goes back and consciously updates the file. You don't get a notification that says, "Personal turbulence has resolved. Please recalibrate your assessment of this employee's readiness for high-pressure assignments." The adjustment simply lingers, quietly shaping decisions for longer than the situation that originally caused it. This doesn't mean you should never lean on anyone during a hard stretch in your personal life. It means being thoughtful about who that person is. A trusted friend outside of work, a therapist, a family member, even a colleague who is a genuine peer rather than someone with structural power over your career. These are appropriate places to process real difficulty. Your direct manager, the person whose job requires them to make ongoing evaluative decisions about your trajectory, is a riskier choice for this kind of disclosure than it feels like in the moment, precisely because the warmth of the conversation in the moment obscures the structural role the person is still occupying underneath that warmth. Category 5. Details about your social life and relationships outside work. This is the category that feels the most harmless, and in many individual instances, it genuinely is. Who you're dating, whose family you spent the holiday with, drama with a roommate, tension in your friend group. This stuff comes out as small talk, the easy, low-stakes texture of conversation when things have gone soft and informal, when you're just being a person rather than performing as a professional. The cost here is subtler than in the other categories, but it's real, and it operates through the same integrative mechanism we've talked about throughout this video. Once a piece of personal social information enters the room, it doesn't stay neatly contained to that one conversation. It becomes part of the lens through which subsequent behavior gets interpreted. Here's a concrete example of how this plays out. Say you mentioned months ago a pattern of relationship instability. You've dated several people in quick succession, or there's been ongoing drama with an ex that occasionally bleeds into your mood at work. Now imagine you have a noticeably off day, distracted in a meeting, short with a colleague, slower than usual to respond to messages. A manager who has no context for your personal life would likely read this as a normal, isolated bad day, the kind everyone has. A manager who has built up a picture of you as someone whose personal life involves a lot of social turbulence is more likely to unconsciously connect the dots, to read the off day not as an isolated event, but as part of a broader pattern they've already started to perceive, fairly or not. This is not really about any individual piece of information being damaging on its own. It's about the cumulative effect of letting your manager build out a detailed picture of your life outside work, because that picture inevitably becomes an interpretive frame they apply, consciously or not, to everything else they observe about you. The unfairness here is real and worth naming directly. What you do in your personal life,
who you date, what your friendships look like, genuinely should not affect how your professional competence is judged. But human cognition doesn't honor that separation automatically. It takes deliberate effort on your part to keep that separation intact because your manager's brain isn't going to do it for you. Category 6. Your past job history in detail, especially what didn't end well. At some point, almost everyone shares the story of how they got to where they are professionally. It's a natural part of building rapport, especially early in a working relationship. And most people's honest career stories include some acknowledgement of difficulty along the way, a previous role that wasn't a good fit, a difficult boss 2 jobs back, a layoff that wasn't performance-related, a toxic culture you escaped from a previous company.
Sharing these stories feels like exactly the right kind of openness, the kind that builds genuine trust and shows you're not hiding anything. And in many ways, it is healthy to be honest about your professional history, rather than presenting a sanitized, suspiciously perfect narrative. The risk lives in what happens after you share it. These individual stories don't stay isolated in your manager's memory. They assemble, over time, into a pattern. And that pattern, once formed, becomes an interpretive frame your manager applies to anything difficult that happens in your current role. The pattern might not even be accurate. You might have had one genuinely bad boss and one genuine layoff that had nothing to do with your performance. Completely unrelated events separated by years. But once they're both sitting in your manager's memory of your history, they start to read as connected, as evidence of a recurring issue rather than 2 unrelated incidents. Here's where this actually costs you. When something difficult happens in your current role, a project goes sideways, a relationship with a colleague gets strained, a deadline gets missed for reasons partly outside your control, your manager has a stored narrative of past difficulty available as a frame for interpreting the new problem. Instead of being read as its own isolated event, the new issue gets quietly folded into continuity with the old ones. You become, in your manager's mind, someone who has had issues before, which subtly and significantly changes who gets the benefit of the doubt when something goes wrong, and who gets quietly held more responsible. This doesn't mean you should lie about your professional history or construct an artificially flawless narrative. It means being thoughtful about how much detail you provide about past difficulties, especially in a casual conversation rather than in a structured interview context, where some of this disclosure is expected and appropriately bounded. There's a meaningful difference between a brief professional acknowledgement, that role wasn't the right fit and I'm glad to be here now, and an extended, detailed account of everything that went wrong, who was difficult, what the dynamics were. The first gives enough context to satisfy curiosity. The second hands your manager raw material that, combined with whatever else happens over the following years, can quietly shape how every future difficulty gets read. Category 7. Any expression of dissatisfaction with your current job, even mild. This is, in my view, the category that does the most consistent, predictable damage, and it's also the one almost everyone slides into at some point, even people who are otherwise quite careful, because the pull toward this kind of disclosure is so strong and so normalized. Here's how it usually happens. You're not in crisis, you don't hate your job, but you've had a stretch where the workload has felt heavy, or you're not totally sure the project you're on is heading in a direction that makes sense, or you're just a little burned out, the way most people get a little burned out periodically. In a normal, friendly conversation with your manager, you mention it. You assume that voicing it is simply part of being honest and transparent, that a good manager wants this kind of input, that this is exactly the kind of authentic communication that's supposed to make a working relationship healthy. Here's what actually happens on the other side of that conversation. Any expression of dissatisfaction, no matter how mild, gets logged, consciously or not, as a data point about your engagement and your likely longevity. And these data points accumulate over time in exactly the same way the financial details, the health information, and the personal turbulence accumulate.
A single mild comment about feeling a bit burned out is nothing on its own. A pattern of occasional comments like that spread across 18 months starts to form a composite impression. This person's engagement might be softening.
Once that impression forms, and this is the part that genuinely surprises people, your manager often starts quietly positioning around your potential exit, sometimes long before you yourself are seriously considering leaving. This isn't necessarily a conscious, deliberate strategy, it's a natural defensive instinct that emerges from risk management. They start making sure your specialized knowledge gets documented and shared with others, just in case. They get a little more cautious about including you in plans that stretch 18 months or 2 years out. They start quietly identifying a potential successor for your responsibilities, just as a contingency. Your continued employment, which used to be the unquestioned default assumption underlying every plan, slowly stops being the default. Nobody tells you this is happening, you simply start to notice, without being able to name why, a subtle defensiveness in how you're being managed, a sense that you're being kept slightly at arm's length from the long-term picture. The deep irony here is that this dynamic often becomes self-fulfilling. The very act of voicing mild, normal dissatisfaction, the kind every engaged employee feels periodically, can trigger the exact managerial response that makes someone less invested in your future, which over time can genuinely push you toward the exit that your manager started preparing for based on nothing more than an offhand comment about feeling tired. This doesn't mean you should bottle up everything and present a relentlessly cheerful facade that has nothing to do with reality. It means being deliberate about where genuine frustration and dissatisfaction get processed. A trusted friend outside the company, a mentor who doesn't have direct power over your trajectory, a journal, a therapist. These are appropriate, low-risk places to work through normal professional frustration. Your direct manager, in casual, unstructured conversation, is one of the highest-risk places to voice it, not because honesty is bad, but because the specific structural position your manager occupies means that even mild, normal dissatisfaction gets processed by them as meaningful signal about your future, in a way that quietly and durably changes how they invest in you. I want to step back here and name the pattern that runs through all 7 categories, because seeing the pattern clearly is more valuable than memorizing the individual items on the list. Personal information, once shared, enters the composite picture your manager carries of you. That picture quietly and continuously shapes the decisions made about your trajectory, decisions you are almost never present for, made in rooms you don't have access to, by people weighing dozens of considerations at once. When those decisions eventually surface in a promotion that doesn't happen, a project you don't get assigned to, a strategic conversation you're not invited into, they always get explained using clean, professional, defensible language, better fit for the role, different team priorities right now. Timing isn't quite right. We want to develop this into a bigger opportunity before we hand it to you. The original disclosure, the comment about wanting to start a family, the mention of financial pressure, the admission of mild burnout, almost never gets named as a factor, because by the time the decision is made, it genuinely isn't a consciously identified factor anymore. It has dissolved into the general texture of how your manager perceives you. The disclosure was the input, the polished professional rationalization is the output, and the gap between those two things, the place where the original personal information quietly became a professional consequence without ever being explicitly connected, is exactly where the damage lives, invisible and untraceable, for years.
This is precisely why almost nobody makes this connection in real time. You can't point to the meeting where it happened, because there wasn't one. There's no smoking gun, no documented decision, no moment where anyone said the quiet part out loud. There's just a gradual, cumulative drift, and one day you look up and realize that opportunities have been flowing somewhere else for a while, and you genuinely can't say why.
I want to be very clear that none of this is an argument for becoming cold, robotic, or suspicious of every interaction with your manager. That would be both miserable to live and counterproductive professionally, because genuine warmth and trust in a manager relationship do create real value. Better collaboration, more honest feedback, a workplace that doesn't feel hollow. The skill here is precision, not withdrawal. There's a meaningful category of information that absolutely belongs in the working relationship, and sharing it isn't oversharing. It's basic professional competence. Your professional preferences, what kind of work energizes you, your career goals as they relate to growth within the company, your honest read on the projects you're working on, your perspective on team dynamics as they affect work output. All of that is exactly the kind of information a healthy working relationship is built on. Withholding that would actually be strange and would make you harder to manage well, not safer. The personal categories we've walked through, your long-term life plans, your financial situation, your health, your relationship conflicts, your social life, the painful parts of your professional past, and your private dissatisfaction, these don't need to live inside your manager's working model of you in order for that relationship to function well. Holding them back isn't deception. There's an important distinction worth sitting with here. Deception is actively creating a false impression. Discretion is simply choosing not to volunteer information that isn't operationally necessary. You're not lying to your manager by not telling them you're thinking about having kids in 2 years. You're exercising a completely reasonable boundary around information that belongs to your private life. There's a related skill that's just as important as knowing what not to share, and that's knowing how to gracefully handle the moments when your manager goes looking for personal disclosure. Good managers do this on purpose and not out of any sinister motive. It's genuinely how most people build trust and rapport. They ask how your weekend was. They ask about your family. They check in when you seem a little off. These questions are usually completely sincere, not traps designed to extract information they can use against you. The skill is being able to answer warmly, with enough texture to feel genuine and human, without actually handing over the specific kind of detail that becomes part of their working model of you in a way that can be used, consciously or not, against your long-term interests. The weekend was great, thanks for asking, doesn't require explaining exactly what happened. I'm doing well, just a busy stretch, doesn't require explaining why it's busy or what's underneath the busyness. You can be present, warm, and engaged in these moments without expanding the file your manager keeps on your private life.
The people who do this most skillfully tend to do it almost without conscious effort. They come across as warm, engaged, fully present in the conversation. And yet, if you actually sat down and tried to list everything they've revealed about their personal life over the years, the list would be noticeably shorter than the warmth of the interactions would suggest. That precision, warmth without excess disclosure, is a learnable skill, and it's genuinely one of the more underrated professional capabilities a person can develop. Here's the piece of reasoning that, once it clicks, tends to change how people approach this permanently. The cost of holding personal information back and the cost of sharing it are not symmetrical. They're wildly, dramatically lopsided, and understanding that asymmetry is the key to making good decisions in the actual moment, when the conversation feels warm and sharing feels natural and holding back feels almost rude. Consider the downside of discretion. At worst, if you consistently decline to share personal details, your manager might feel that they don't fully know you as a person, that you keep work and life cleanly separated, that you're a bit private. That's a real cost. Most people prefer warmer, more open relationships, and a manager who feels kept at arm's length might invest slightly less personal energy in the relationship as a result. But notice something important about this cost. It's bounded. It has a ceiling. The worst realistic outcome of being appropriately discreet is a relationship that's a little cooler than it could have been. That's genuinely the floor of the downside. Now consider the downside of disclosure.
Once personal information leaves your mouth, it enters a system you no longer control. You cannot predict how it will be used, when it will resurface, what decisions it will quietly influence, or how long its effects will persist. The downside isn't bounded at all. It's open-ended, compounding, and largely invisible until you look back years later and realize your trajectory looks different than it should have, for reasons you can never fully reconstruct or prove. This asymmetry, a bounded, modest cost on one side and an unbounded, compounding, invisible cost on the other, is the single most important piece of reasoning in this entire video. And yet most people, in the actual moment of conversation, choose the larger, riskier cost because being candid in the moment is simply easier and more emotionally satisfying than being careful. Candor feels good immediately. Discretion pays off slowly, invisibly, and only over a timeline most people don't naturally think in. Where exactly you draw this line is a personal decision, and there's no universally correct place to put it. Some people will choose to hold things tighter than others, and that's a legitimate individual choice based on your own risk tolerance, your specific workplace culture, and your specific relationship with your specific manager. What I'd say, based on the consistent pattern I've seen across thousands of career trajectories, is that most people draw this line too loosely, and they pay for that looseness in ways that don't become visible until years later, by which point the cumulative effect of small, individually harmless-seeming disclosures has quietly shaped their career into something that no longer looks like the product of any single decision anyone consciously made. Understanding the mechanism is necessary, but it's not enough on its own. You need a practical way to actually apply this in real conversations in real time without becoming someone who seems guarded, suspicious, or unpleasant to work with. Here are 5 concrete moves.
Move 1. Build your mental category list before you need it. Right now, before your next casual conversation with your manager, mentally sort the 7 categories we've covered into things I generally don't volunteer in your own head. This isn't about memorizing a rigid script. It's about having the categories preloaded so that in the actual moment, when a casual question opens a door toward one of these topics, you have an instant internal flag, rather than having to think it through in real time under social pressure with the conversational momentum pulling you toward openness. Move 2. Use the warm deflection, not the cold deflection. There's a meaningful difference between "I'd rather not discuss that," which reads as guarded and can actually damage trust, and a warm, specific-sounding non-answer that satisfies the social moment without handing over the substance. "How was your weekend?" can be met with "really good, needed the break," rather than a detailed account of a family conflict that happened during it. The warmth lands, the risky detail doesn't. Move 3. Redirect toward work-appropriate disclosure. When a conversation drifts toward personal territory, you can often redirect it gracefully toward the category of information that is appropriate to share: your professional goals, your read on a current project, what kind of work you're hoping to do more of. This keeps the conversation feeling open and engaged, while steering it toward content that actually serves your career, rather than quietly working against it. Move 4. Separate your support network from your reporting line. Make sure you have people in your life, friends, mentors outside your direct chain of command, a therapist, family, who serve the role of processing real difficulty, frustration, and uncertainty. If your manager is the only person you talk to regularly, the pull to overshare with them becomes much stronger, simply because the need for connection and processing has to go somewhere. Build that outlet elsewhere, and the pressure to overshare with your manager drops substantially. Move 5. Periodically audit what you've actually shared. Every few months, take a few minutes to honestly reflect on what you've told your manager over the recent past, not to spiral about it, just to notice patterns. If you realize you've been consistently sharing detail in one of the 7 categories, that's useful information. It doesn't mean disaster is coming. It means you have an opportunity to tighten the discipline going forward before the cumulative picture gets too deeply formed. Here's what I want you to take away from everything we've covered today. This isn't a video about distrust. It's not an argument that your manager is secretly working against you, or that warmth and connection in a professional relationship are dangerous things to be avoided. Most managers are decent people, doing a genuinely difficult job, and the relationships you build with them can be some of the most meaningful professional relationships of your career. What this video is about is understanding a structural reality that almost nobody explains clearly. Personal information, once shared, doesn't stay contained to the moment it was shared in. It becomes part of an evolving, integrative picture that quietly shapes decisions about your trajectory for years afterward. Decisions that get explained, when they happen, using clean, professional language that never names the original disclosure as a factor, because by then, it's genuinely not a consciously identified factor anymore. It's simply part of the texture of how you're perceived.
The conversations that felt the safest in the moment? The ones where your guard came all the way down, where the coffee was warm and the conversation felt like it was between two friends rather than between an employee with someone with structural power over their career, are very often, statistically and consistently, the ones that produced the most lasting, invisible damage. The conversations that felt a touch more guarded, a touch more careful, where you stayed warm and present without fully opening the door to your private life, those are very often the ones that protected you, without you ever consciously realizing they were doing that protective work. Be friendly, be present, be genuinely human in your work relationships. That matters. And a workplace stripped of all warmth is a worse place to spend a third of your life. But underneath all of that warmth, hold these 7 categories with a little quiet care. Don't let the comfort of a single warm conversation talk you out of a discipline that only pays off on a timeline of years, not minutes. That's it for today. This was a long one, and if you made it all the way through, I genuinely appreciate it. Drop a comment. Tell me which of these 7 categories surprised you most, or if you've noticed this pattern play out in your own career. Subscribe if you're new, share this with someone who needs to hear it before the next casual conversation with their manager, and I'll see you in the next one.